code. And again, that is one. And then number two, in the areas of lawmaking power, in the areas of the domain of lawmaking, in Islam, Allah is the only sovereign. Whoever is going to take the position of lawmaking, he is only doing it as far as the pleasure of the Almighty extends to. That is to say, whatever lawmaking, whatever law that you are going to do, it must be in tandem with the divine guidance and also the divine principles. But of course, as you do know, man is a sovereign being under liberal democracy. So because of that, he has every right to make any law because you are a sovereign. You are a sovereign, you have sovereign power, so you can make laws. That justifies all these laws that we have said. Yes, these laws under Universal Declaration of Human Rights, under CEDAW, under Child's Rights Act, under Samoa, and whatnot. This is the reason why they have every right to do it, and nobody can say no to it. And then international conventions also, they originate from secular and, you see, Western values and Western standards, where Shari'ah originated from divine and immutable sources. And then area of convergence, I said from three perspectives.
Thank you very much.
Yes, from three perspectives. Just give me 1 minute to conclude. Islamic law of treaties, we have this as a principle. We also have Islamic law of external relations.
Thank you very much, Prof. Prof, can you hear us?
Yes. So these are the areas of convergence, and then we have areas of divergence. And I have concluded. The conclusion, I think you can all see it. I would have loved actually to read the conclusion, and it's just one paper. Can I go ahead to read it?
No, you can go ahead.
Hello, can I go ahead? I have concluded. Reforms, I said they nurture harmony and global cooperation. They also promote global peace. Sharia is not averse to reforms, as we have said. Sharia codifications are not objectionable except where they are anchored on Western philosophical standards, human rationality, feminist and liberal women liberation ideology, or liberal democracy informed by tradition of Western scholarship. One of the main objectives of this, I have said it, areas of convergence and divergence have been highlighted, and then codification of Islamic family law is not and has never been a solution to family and marital problems. There are recommendations, which is the final I have said, Muslims and states should take advantage of areas of convergence, and then where there are divergences, then they should be able to. These conventions, they should either sign them or refuse signing them initially, or if they have to sign with strong reservations. And then codification of Islamic family law has never been a solution. I said what is needed is behavioral and organizational change based on genuine Islamic teachings is the remedy to our own problems. The Muslim and non-Muslims should adhere strictly to the teachings of their religion, and they must not allow interference with their values, cherish norms, religious teachings, and family systems through conventions that stem from Western liberal democratic ideas. However, where such conventions are free from such antics, Muslims should cooperate to see to their actualization. And then finally, I said all will be accountable to their actions before Allah subhanahu wa ta'ala on the day of judgment, and including our obligations that arise either from conventions or from treaties that we have signed or we have ratified, whether at international or at local level. I thank you all for listening. I give you for the opportunity given to me. Thank you very much. Assalamu alaikum wa rahmatullahi wa barakatuh. And I go. Yes.
Thank you very much, Professor. That was an inspirational and educative keynote address. We appreciate and commend your sacred efforts. Thank you very much. Moving on to the next agenda is the first lead paper presentation by Professor Usman Muhammad Shuaib. If permitted, I would like to share a very short encounter with Professor. Professor Usman Muhammad Saeed taught us GSP during our undergraduate at Bahrain University, Kano, and his GSP class was very memorable. He taught us on legal rights, copyright, trademark, and insignia. So one memorable example that still makes me smile, if I remember, was I thought that when you buy, for example, a Coca-Cola, you normally know that Coca-Cola is a sealed bottle. When you drink it, it tastes like Dogo Dogo. Then you can sue that company. So that is something that we still remember that point in memory. I thank you very much, Professor. So Professor Osman Mahmoud Shai, popularly known by his sobriquet, Prof. Zulu Rain, is a professor of Islamic law at Nara University, an indigenous of Katsina, Funtua local government. He holds a royal title as Jakadam Funtua. He earned both his law degree and master's at Nara University, Kano. He holds another LLM in human rights at the University of Essex, United Kingdom in 2005. And he passed his PhD in Islamic law at Ahmad Bello University in 2014. His first employment was as Katsina State Minister of Justice from 1995 to 2000, which later he joined the services of Nara University, Kano in 2001, where he has been a lecturer at the Faculty of Law for over 20 years. His areas of specialization are Islamic jurisprudence, textual exploration and contextual analysis of legal issues, and Islamic law of contracts and Islamic finance, among others. He conducted research in different areas of law and have published scholarly works. His researches have been published by reputable publishers in books and articles in national and international journals. He had acquired vast experience as a legal expert and administrator. He is serving as Director of International Banking and Finance, the Dean of Law, member of CBN Financial Regulation Advisory Committee of Experts, and a member of Katsina State Shari'ah Commission. As mentioned earlier, he is appointed as Jakad and Katsina by Sarkin Maskan Katsina, Hakim Funtua in 2022. Professor Nuren is a bilingual writer and is respected by the Nigerian community of lawyers, and his mode of teaching is cherished by his students. Ladies and gentlemen, I give you Professor Nuren. Welcome, Prof.
He's with the system. I thought he has already come. So what do we do? You're not option yet. I did. النبي الكريم سيدنا محمد وعلى آله وصحبه أجمعين وبعد السلام عليكم ورحمة الله تعالى وبركاته. The Vice Chancellor Sir, heavily represented by the DBC, distinguished principal officers of the university here present, in breach of protocol, my Lord, my noble Lord, and my chairman, my leader, the Grand Vicar of Katsina State, Dr. Muhammad Kabir, and the Honorable Qadi of the Sharia Court here present, other distinguished members of the front seat, distinguished participants at this second international conference that has just been declared open this morning by the PC. I'm called upon to speak after the presentation of my teacher, who just finished speaking to the keynote address, Professor Mansour Said Ibrahim, was my external examiner during my PhD viva, and incidentally, I wrote my PhD on the Taqaneen Ahkamu Shari'ah. I wrote on the codification of Islamic criminal law. You know, I tried to look at some issues around that area. And I can remember when Prof came for the external examination, he made a recommendation that it should be outrightly, or it should be published. And ABU took that responsibility for getting it published on the web. So it used to be on the website of ABU, and it has been online for quite a while. I don't know whether it is still there. I'm sorry, my time has not started running because my computer analyst is in the Dean's office working on my slides, just putting some finishing touches. I completed the paper on our way from Kano to Katsina. So I have been calling him to come in, but I think he's just taking his time to correct the slides. So please, I beg your pardon to allow me have him so that I can speak to the slides. That is the only thing that may be delayed us. I don't know what we're going to do. If we have a particular item that we can dispense with before arrival of Ali from the Dean's office, I think we do that. Do we have another item? Okay, please come and take it off so that my time will not be running. I am not like my teacher. You cannot stampede me into concluding midway because I'll not make sense if I've not explained myself properly. So Jazakumullah khairan. The Coca-Cola should be here as well.
Inshallah, that was really humorous. Inshallah. So based on this, we move to the next agenda, which is the goodwill message by the special guest of honor, the Grand Qadi of Katsina, Walin Galadiman Katsina, Dr. Muhammad Kabir Abubakar. He will give us the goodwill message.
الآن ندعو إلى هذه المنصة فضيلة الأستاذ الكبير ليلقي خطابه التبريكي لهذا المؤتمر في دقائق إن شاء الله، ثم نمشي إلى النقطة الثانية.
الصلاة والسلام على رسول الله صلى الله عليه وسلم. Baki da suka halarci wannan wuri masu tsarawa wannan taro, sauran participants, ne muku barka da zuwa, ne muku fatan alkhairi. Allah ya albarkaci wannan taro namu, Allah ya sa mu yi shi lahiya, mu kare shi lahiya. Shi me aka ce zan magana? Fatan alkhairi. Fatan alkhairi. To ina mana fatan alkhairi wannan taro da aka shirya akan abin da ya shafi shari'a da modern, ya za mu fassara modern global reforms, gyare-gyare na modern ci gaba kenan na zamani, contemporary na zamani. Ai wato ni a fahimta ta ita ce modern reform, ita ce modern reform. Da ne ake cikin rayuwa ta banza sai Allah ya kawo gyara. So yanzu wani ya dago kai ce zai yi modern reform a cikin shari'a, ya yaudara shi. Ka sa abin da yasa muke samun wannan matsalin, waɗanda ke maganar reforms ba su taɓa sanin daɗin shari'a ba dama, cikin ƙazantar suka taso. Wani yamuri da ya musulunta ya magana ta burge ni, ya ce ku musulmai ba ku san daɗin musulunci. Sai mamaki da yasa daga shigowar shi ke faɗa kai, ya ce mu, ya ce su da suka rayu cikin kahirci suka san ƙazantar da suka taso cikinta, inda mutum bai bambance uwar shi da ɗiyar shi da matar shi, suka shigo cikin hasken musulunci, su za su musulunci. Amma ku da ba cikin daɗin kuka taso, sau ku san shi daɗin ba. To abin da yasa ake samu ake maganar cewa ana neman legal reforms a shari'a. Abin da ake bukata shi ne a fahimci menene shari'a. Shari'a ce har yanzu ba mu fahimce ta ba. An gani saboda ita fassarar nasi tana tafiya daidai da zamanin da za a yi amfani da nasi. Zai wahala lokacin da aka fassara nasi a ƙarni na goma ko ƙarni na can baya ya yi daidai da yadda an fassara shi a wannan ƙarni. Akwai matsalolin a samun bambanci. Ya za ka koyi mutumin da zai fassara أفلم يروا إلى الطير فوقهم صافات ويقبضن lokacin da ake fassara farko walla illa rahman to jirgi shi ya fi cancanta ya ɗauki wannan ma'anai domin jirgi a
We have the next line of awards presentation to Alhaji Dr. Muhammad Usman Sarki, the CEO, Chairman Al-Busar Nigeria Limited. We call on Alhaji Isa Usman Sarki and the Grand Kadi Mustafa Sani Solawa to present the award to Alhaji Muhammad Usman Sarki. So for us to know Dr. Muhammad Usman Sarki, CEO and Busar Nigeria Limited, first of all, he was born in the year 1980 at Kofar Buga, in Katsina Metropolis. He started his formal education at Kofar Buga Primary School, which he completed in 1992. He then proceeded to Government Age Secondary School, Kofar Entaka, and Government School Malumfashi, which he completed in the year 2000. He then proceeded to Federal College of Education, Kano, where he obtained a diploma in public administration in the year 2008. He held a BSc in Business Entrepreneurship at Open University. He also obtained a professional diploma in ICT from Dialogue Computer Institute in the year 2009. He is happily married with children. We really honor his presence. Congratulate him. It calls on to us to know about him as well. Haji Shaibu Shitu was born on 5th October 1963 at Kafanchan, Jama'a local government of Katsina State. He attended primary schools by Kogi, Kafanchan, later attended government secondary school GSS Kaguru. From there, he proceeded to Katsina and attended Arabic Teachers College, Katsina in 1987. He later proceeded to Al-Qalam University, Katsina, where he earned his degree. He has been in car business and become the CEO of Maslaha Motors. He's a classroom teacher before and a grassroots politician. After a long struggle, he became the chairman of the state ruling party, the APC. He happily married with children. We are ready, we can go back to the newspaper presentation. We call on to Professor Osman Muhammad Shai to give us the newspaper presentation. Welcome.
Mr. Chairman, distinguished participants, permit me to stand on the existing protocol. I was already on the stage before I get down in order to get my slides ready. The title of my paper is, that I can say it is destabilizing the poll, and I would like to speak to the audience. Yes, the title of my presentation is Shari'ah as a Compass for Navigating Global Legal Challenges. Well, the choice of this title was done in consultation with organizers of this international conference. And what I seek to do in the presentation is to use Shari'ah as quality controller. Shari'ah, one of its attributes, it is a quality controller. وَمُحَيْمِنًا عَلَيْهِ. As a plan of analysis, whatever conforms with Shari'ah, that should be legal. Whatever is in conflict with Shari'ah, that should be illegal. Why? Because Shari'ah is a legal system that is ordained by the Creator. Allah lahul khalq wal amr. Allah subhanahu wa ta'ala has the creation. The creation is His. And the manual that should control the operation of that creation should naturally come from Him. And Allah told us in Surah Al-Malik, Allah ya'lamu man khalaq wa huwa al-latiful kabir. The one that creates shouldn't know what is better for his creation. So that's why we use Sharia as a compass for navigating the global legal challenges. I must, as my teacher did before, enter a sort of caveat, because at the end of the day, we may find ourselves touching a lot of surfaces, scratching surfaces without going deep, because the area is too wide. The challenges are myriad, and the areas are so vast, which cannot be covered in cannot be covered in a single presentation like this, that I have only 30 minutes. Let me be guided by the time. So that is the essence of this. Now, at the introductory level, I try to discuss Shari'ah as a legal system, Islamic law as a legal system. I'm not giving the definition of Shari'ah, nor am I making any attempt to define al-hukm al-shari, which is the Islamic rule of law. But what I try to do is to, try to predict, try to explore areas that have been covered by Shari'ah. And this is, like it's inexhaustive. Any new emergent issue would have Shari'ah being extended in order to cover it. And that's the relevance of qiyas. That's the relevance of ijtihad. And even maqasid Shari'ah, that a lot of people are making hues and cries about it. We students of Sharia law, we know very well that it is a tiny window within qiyas as a source of Sharia. Usually, our predecessors, the jurists, they discuss maqasid Sharia in its two ramifications. When we are dealing with maqasid, it is either ta'lilul ahkam, giving the illatul hukum, giving justification for a kind of for a ruling of Sharia, or you are looking at the kulliyatul khams that were discussed by Professor Mansour Ibrahim Said. So with both its ramification, the jurists, if you look at the muwafaqat of Imam Shatibi, try to capture it as a tiny window within the discourse about qiyas. And unfortunately, those who want to stretch Sharia in order to conform with modernity, they are using the maqasid in virtually every aspect of Sharia. So we need to understand this. But in this introduction, I make the point that Sharia includes a wide range of regulations and ethical norms. And that is the fundamental difference between Sharia principles and the common law legal system. Under the common law, law and morality are not coextensive. Law and morality are far from being coextensive. So if something is immoral, may not necessarily be illegal as far as the law is concerned. Because the law, according to common law, is what the leader says to be the law. And going by our Nigerian legal system, is what the legislature, the National Assembly, the state houses of assembly say or agree to be the law. So it may, an illegal and immoral act may not necessarily be illegal. And that's why you find conflict here and there when you are trying to enforce Sharia. But in Sharia, there is unity of purpose, if I may use the expression. There is fusion between the law and morality. Whatever is immoral is from Sharia point of view is illegal. Whatever is legal, be it as it may, it is moral. You may not understand the wisdom. You may not understand the morality behind a particular legal ruling. But وَلَوْ إِلَى الرَّسُولِ وَإِلَى أُولِي الْأَمْرِ مِنْهُمْ لَعَلِمَهُ الَّذِينَ يَسْتَنبِطُونَهُ مِنْهُ. If you should have taken it to somebody who is more grounded in the sources of Sharia, he would have guided you to the illatul hukum that is in conformity with morality. So it encompasses all these aspects of things, and therefore it governs our personal, our social, our economic, our justice system, and all our mu'amalat, be it private or public in the governance area. So we need to understand this clearly right from the word go of this presentation. Yes. Okay. I continue under the introduction to capture the specific issues in the international discourse today. in the international legal discourse today. Issues having to do with climate change, migration, international trade, governance, human rights, and all other concerns that are the issues at the front burner of the international legal discourse. So all these issues, we know they are there, and other varied legal and ethical traditions. Sharia as a comprehensive and dynamic legal system, an adaptable legal system as well, has the capacity to shape all these international discourses. Anything you are having problem with, if you return it to Sharia, you will surely find an answer. And that verse that I cited before, وَلَوْ رُدُّوهُ إِلَى الرَّسُولِ وَإِلَى أُولِي الْأَمْرِ مِنْهُمْ. If you have taken it to the legal scholars, Sharia scholars, they would have given you a way out or whatever you are discussing. So this paper tried to look at some of the solutions that Sharia has given to some of these burning issues that legal scholars are engaged with, that engage the mind of our best legal scholars internationally. But because they don't know Sharia, they cannot understand the solution easily. They are, they are like groping in the darkness. They are grappling with the issues. They are struggling with the issues, trying to find the solution. While the solution is there, anti-Sharia provisions. So we need to understand this. Yes. In the next slide, I try to look at Sharia vis-a-vis the concept of human rights. Here, I'm not going to take much of your time on this issue. We all know the history of human rights. After the Second World War II, initially after the First World War, the international community came together and set up a League of Nations. League of Nations was set up in order to prevent the world from undergoing the Second World War. That the bitter experience that humanity has passed through is such horrible experience that humanity doesn't like to undergo again. And therefore they say, what's the way out? Let the international community come together under a League of Nations in order to prevent the world from going into war again. Unfortunately, because League of Nations operate on certain permits, certain issues having to do with non-interference in domestic affairs, sovereignty principle, and so on and so forth, that arrangement wouldn't prevent world from going into the Second World War. Now, after the Second World War, specifically in 1946, the world says, look, the League of Nations arrangement couldn't save us from war. And therefore, there is need to move away from all those issues of non-interference, of sovereignty, of blah, blah. We need to come and establish international institutions that will govern the humanity and thereby prevent the happening of a third world war. So for that reason, United Nations Organization was set up, and the United Nations Organization Charter established that the world should have a General Assembly, Security Council, and so on and so forth. And any war that has no authorization of the Security Council is considered as jus ad bellum. Jus ad bellum, meaning unjustified war. But by doing this, the world is trying to prevent, the happening of the Third World War. Now the world kept on moving on to the extent of establishing International Court of Justice in order to have an international judicial arm to deal with rebels who are trying to foment trouble within the international community. All this bring about, human rights movement in the world. I'm not taking us down memory lane to discuss the Universal Declaration of Human Rights, which preceded all this arrangement. But in 1945, the world made declaration that they call Universal Declaration of Human Rights. Now, like the name presupposes, it is mere declaratory document. It's just making declaration. It's not a treaty, nor is it a convention. But the human rights scholars are of the opinion that because UDHR, Universal Declaration of Human Rights, informed a number of constitutional order in civilized world. It attained the status of customary international law. So they are looking at UDHR as, although it is not a treaty, but it has attained the post of a treaty because it can as well be considered as international, as customary international norm, customary international law. For that reason, they gave it prominence. But nevertheless, because the movement of human rights once enforced the human rights, they decided in 1966 to come up with two international covenants. International Covenant on Civil and Political Rights, International Covenant on Economic, Social, and Cultural Rights. The reason for having the two covenants is because of the polarized politics of the world then. You know, we have a bipolar international politics. The Western state, the Western nations, the capitalist countries, led by America and Europe, they are saying the most essential, fundamental human right to humanity is civil and political rights. Right to life, right to personal liberty, right to peaceful assembly, all these rights, they are the most important. Now, the Soviet Union, leading the Eastern Bloc, they are saying, what's the essence of life? If you don't have right to work, if you don't have right to economic empowerment, you gave me the right to life, you didn't give me the right to work in order to sustain the life. So they say the most important rights as far as humanity is concerned are economic, social, and cultural rights. Now, when the world cannot attain consensus, they cannot reach unanimity on this issue, then the two covenants were put up together simultaneously and they were open for signature. If you want to go the Eastern Bloc way, you accede to International Covenant, social and economic rights first. If you want to go to the Western capitalist, polar, then you go for international civil and political covenant on civil and political rights. Now, for Nigeria, which is a relevant issue to us, and that's why we need to know the position of Sharia on this, we took both the two covenants. Nigeria is a signatory to both the two international covenants, which are legal and enforceable treaties. The International Covenant on Economic and Cultural and Social Rights are contained in the Chapter 2 of the 1999 Constitution as amended. And that is what the premise of our Constitution called Directive Fundamental Objectives and Directive Principles of State Policy. So the entire content of the ICESCR are contained in the Chapter 2 of your 1999 Constitution as amended. I'm coming back to that. Let's keep it at this point. Now, when you go to the International Covenant on Civil and Political Rights, the entirety of the contents were dictated by the premise of Nigerian Constitution, and they put it under Chapter 4 of the 1999 Constitution. And this is what they call fundamental human rights. I hope we are following the discussion. Now, going by the provision of the Constitution, the fundamental human rights, which are essentially contained in International Covenant on Civil and Political Rights, are the fundamental human rights, for which they should be protected at all costs. You don't need to wait for your fundamental human right to be violated before you rush to court. Very soon, if we have the title personal being, deleted or expunged from our Constitution in terms of Islamic law, you can rush to the Grand Qadi and ask him that my fundamental human right is about to be violated by the government of Katsina State. Another name we give it as student of law is we call this fundamental human right as negative rights. Negative rights in the sense that These are rights that are telling the people in the corridor of power that these are your limits. These are limits beyond which you cannot go. That's why you find people filing enforcement of fundamental human rights against the government, against the governor, against the president, against everybody. You can just rush to court once your rights are likely to be violated. Now, this is how this was protected. And you can see the politics, perhaps because it is rooted in the capitalist Western orientation. Now, the ones that has come from the, the Soviet Union and the communists, the Covenant on Economic, Social, and Cultural Rights are in Chapter 2. And the entire Chapter 2 was declared as non-justiciable. Non-justiciability presupposes that you cannot take the government of Katsina State to court because it was not able to provide you with work. You are a graduate from Al-Qalam. You cannot rush to court to say, I have graduated for the last 5 years. I couldn't get work. And I'm an indigent of Katsina State. I want the governor to be brought to court and be forced by way of mandamos to give me work to do. You can't do it because right to work is not justiciable. It's the directive principle, and therefore it is not mandatory to be implemented. Or at least they should be implemented progressively with a view to realizing them depending on the availability of resources at the disposal of the government. So it all depends whether the government has the resources, and the resources are very limited. You cannot take the government of Katsina State or the government of any other state to court because it cannot provide you with sound education. Education is part of the economic, social, and cultural rights, and it's in Chapter 2. It's part of the fundamental objectives and directive principle of state policy. So I hope you are following the discussion. You cannot take the government to court because it couldn't provide you with health care delivery, effective and efficient health care delivery. I'm having malaria, I'm sick, there's no free hospital for me to go and do the consultation and get medication. And perhaps that's why all our hospitals are consulting clinics. So they are, in a nutshell, non-justiciable. And that is the provision that human rights made. That's why I say I was coming back to Chapter 2. Now, that was the beginning of the human rights movement. From UDHR to the two international covenants on civil and political rights, on economic, social, and cultural rights, the movement graduated to another level. The next level was to start making it as part of thematic rights. Right to self-determination. Any minority that want to lead a particular entity, perhaps like IPOP, these indigenous people of Biafra, they want to lead Nigerian contraption, they have the right to self-determination. This is also part of human rights. Then they graduated from that level and they start talking about human rights in terms of orientation. Now, if you take Section 41, I think Section 41 is talking about non-discrimination. No one should be discriminated against on account of the circumstances of his birth, or a religion, or orientation. And it is on that basis that issues having to do with sexual orientation started being put at the front burner as part of human rights issues. So a person now has the right, if they ask you about your gender, now in Europe and America, they don't ask you about your gender anymore. Because the gender now is uncountable, is limitless. You can either be man or woman or none of the above. I will get the point. Transgender, bisexual, asexual, queers, and so on and so forth. And that's where you have the LGBTQ movement as part of human rights. Now we get the point. Now, from my study of human rights, I am of the belief, which may be wrong. In academic, we have to open up to this reality. I am of the conviction that if the judge will appear the Jan will appear under the movement of human rights. Because he will come claiming for one right or the other, and the international community will give him all the necessary support. So that in a nutshell, before the international community. Now looking at it from Sharia point of view, you find that Sharia did not distinguish between economic rights and human and civil rights. And that's why the fundamental human rights under the Sharia are those maqasidu Sharia we are talking about. Maqasidu Sharia as kulliyatul comes this time around. Not maqasidu Sharia as ta'lilul ahkam al-Sharia. So you find that what we are dealing with are the kulliyatul comes. And when you are dealing with kulliyatul comes under the Sharia, you start with protection of religion. Hifzuddin. Because protection of religion takes the priority over all other rights. For protection of religion, you can sacrifice lives. And that's why jihad was legalized. Whoever is trying to be a stumbling block on the way to propagation of Islam, on the way to enforcement of Sharia, his life can be sacrificed for Sharia to take its place, rightful place of affairs. So for that reason, now the protection of a deen, protection of religion takes priority over any other protection. Because Allah subhanahu wa ta'ala told us in the Quran, وَمَا خَلَقْتُ الْجِنَّ وَالْإِنسَ إِلَّا لِيَعْبُدُونَ. Allah created man and jinns for the sole purpose of worshiping Him. And that's why your first fundamental human right is the right to religion, is protection of religion. Although freedom of religion is one of the fundamental freedoms under the human rights movement, and therefore it forms part